Welcome to Solving Citizen Legal Encounters. All right, today we're in a landlord-tenant dispute with a pro se defendant who wants to see what he can do on his own with his case. So let's go in and see how this case is going to turn out. And also, I have to welcome a new member by the name of Beverly. Beverly, thank you for joining the membership. Check out the community post. There's something there for you. Let's go.
This is the matter of Pacific Flats versus Joshua Johnson, 25-03115. Appearance, please.
Good afternoon, Judge Christopher Asphalt, 53129 on behalf of the plaintiff. I am Josh Johnson.
You're all square. Your plaintiff, you should be over there, but that's okay. Today was the date scheduled for a hearing for termination of tenancy. My understanding is that you all were not able to resolve this. Is that accurate?
That is accurate.
Okay. And so you believe that you have a lawful right or reason to hold over the property, sir?
No, actually, well, I have a lawful reason why they cannot evict me.
What's that reason, sir?
The reason is because one, they stole money from me, and two, they failed the inspection of set forth by LAC.
They stole money? How did they steal money from you?
They stole $1,400, or sorry.
Said how?
How? By taking it out of the account that I put money into the account. I put extra money in there every month.
What account?
Into the rental account. I put
So there's an account that you can prepay money in or something?
No, I pay into the account for my rent and I put extra in there. So that way it was there for a rainy day. My ledger shows that. Their ledger shows that they conveniently erased that $1,400 through their ledger by altering certain numbers, by changing certain numbers. And I got the proof right here.
That's a large stack of papers for a ledger.
Yeah, that shows what they did. So they stole $1,400, $1,398.90 in October 21st.
You're prepared for a hearing today?
Yes.
Okay. You can have a seat. We'll call in just a minute. Let me get Mr. Ty. We asked Mr. Tyler to come and he walks back out.
He just walked out.
I don't know why when we called him in here.
Right.
You can have a seat.
Thank you.
Back on the record in the matter of Pacific Flats versus Joshua Johnson. Counsel, you can make your case.
Your Honor, can I briefly address the court with opening argument? I think it's
Absolutely
pretty relevant. So, Judge, this is a termination of tenancy case for seeking possession only. There's also a separate case pending for non-payment of rent in which the defendant has filed a counterclaim in that case. As again, this case is for possession only, termination of tenancy based on the lease is now month to month, and we sent a 30-day notice and we're seeking possession of it. From what the defendant is telling me has addressed to this court, I believe he's willing to give up possession of the property. He just wants to be able to pursue his claim for money damages against my client that he was referring to. So it's my position, as the facts will unfold, I believe that, this whole issue of my client owing him money is not really relevant to this termination of tenancy case. That being said, I'm ready to call my first witness.
Proceed. Who are you calling?
Sorry, Teresa Williams.
She's calling herself. You raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. You can have a seat. Please state your first and last name and spell both.
Teresa Williams, CHARISA WILLIAMS.
Thank you. You can proceed.
And Ms. Williams, what is your position at Beverly Place Apartments?
Living now, I'm the property manager.
Huh? I thought she was one of the tenants.
Okay. And are you familiar with the business record practice for the plaintiff?
Yes.
And are you familiar with the tenant known as Joshua Johnson and his ledger and file?
Yes.
Your Honor, I'm going to approach the witness with the proposed Exhibit A. Are you familiar with that
Yes.
document? I believe you have a copy of it, so you can give it back in. And can you tell the court briefly what that document is?
This is a 30-day notice to quit.
And it was provided to Mr. Johnson before we filed the complaint in this case. Is that accurate?
Yes,
What date does it indicate that it was served upon him?
April 29 of 2025.
And how was it served?
First class mail,
Said April, what date?
29.
Your Honor, do you want me to submit the Exhibit A directly to you?
It's marked already?
Yes,
Yep.
I just marked it by writing on it.
So it's gonna be one though, exhibit one.
Okay.
Any objection to plaintiff's exhibit one? Is that a no?
I'm sorry, I'm not sure what is it.
It's the notice to quit. Do you want to review it?
I've seen it before. It's been given to me. So yep, I do know that.
Okay, exhibit one is admitted.
And this is proposed Exhibit 2, which is a lease. I'll show it to the defendant first.
I've got like 20, 30 of these they've sent me, but as far as I can see right now, everything looks fine.
When you
Plaintiff's
approach-
exhibit two is admitted. You're
Exhibit-
gonna approach.
Yeah, I just want to make, okay, let's take a quick look.
Yeah.
All right, do you recognize the proposed Exhibit 2?
Yes,
And can you tell the court briefly what it is?
yes, it is the lease agreement signed by Mr. Johnson.
And what was the date of the lease?
It was entered into, or signed, sorry, on May 6th of 2016, ending May 31st of 2017.
Thank you. I'm going to approach the court with my proposed Exhibit 2.
It's already been admitted.
Okay. Are you aware, or is it your understanding, you have knowledge that the defendant is still living in the property?
Yes.
Actually, Judge, I'd like to allow to recall this witness if necessary, but at this point in time, I don't believe I have any more questions for her.
Thank you. Do you have any questions for this witness?
No, the black one will speak for itself.
I'm sure an attorney would have asked something.
Okay, you may excuse me. Any other witnesses at this time?
No, Your Honor.
Thank you. Are you calling any witnesses today? Are you presenting testimony yourself?
Yes.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I'm sorry, one thing, Your Honor, I may need to call my aunt. That's the only thing, though.
That's up to you.
Okay, that's the only.
Do you
person.
solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, tell me what you want to tell me that you believe is the lawful right for you to hold over the property.
Okay. Your Honor, I've been there at this property for now almost 10 years, never been late on a single payment, never had any issues there until these people took over ownership. The $1,400 is what started this whole ordeal, but that's the beginning of it. What it is that their inspections, they have continuously failed. And I myself have been actively looking for a place to live, or looking for another place since March of this year. I have found an apartment. LHC is willing to let me be able to move as well too. And the new apartments have already agreed to let me move in as well too. I've already got the move-in packet with them. I've got emails from LHC stating that I'm good to go, as long as Pacific Flats is not able to evict me.
Okay, let me stop you. You're looking to move. When are you gonna be able to move?
July 31st.
The end of this month?
Correct. That's all I've been waiting for. LHC would not allow me to move until I was able to make the paperwork,
What paperwork?
the move out paperwork before the first of the month that I wanted to move.
You
I
have
had
to
to
make
move
the
before
move
the
out
first.
paperwork? What do you
Yes, the
mean?
move out packet for LHC. for
Okay,
the
have you done
license.
that?
I'm sorry.
And you've done that?
Yes, the new apartments have it and LHC also has it as well too.
Okay,
Yep.
and so the reason why you want this hearing is because you don't want an eviction on your record? Is that what you're saying?
Correct. So that way I can stay on Section 8 because the only reason why I see them trying to get me in on August 12th, they have another court date to evict me on August 12th. They know I've been trying to move all this time. They know I have.
So you already have an apartment?
I have it all set up. I'm just trying to get out.
Show
I'm
him
just
the
waiting.
paperwork that you have a new apartment.
I hope so, because he has enough on that desk.
Have an email from LHC stating I'm good to go to move on the 31st.
No,
Okay.
that's not what I asked you.
Okay,
Did you show him
okay,
paperwork
okay.
that you got a
That's
new
fine.
apartment?
Be sure. So, I just need 1 second to be able to find it though. I apologize. A lot of paperwork I had to keep over almost a whole year.
A minute and a half into him looking for the paperwork, the judge stepped off the bench for about a minute. She came back, and the total time that he was looking for the paperwork was about 4 minutes.
Back on the record. Did you find your paperwork?
Yes, Your Honor. Most of my stuff will be easier if I find it on my phone.
Did you find your paperwork?
Yes.
I'm asking you.
Sorry, yes.
Okay. You have it? I need to see it. Did you
Yes,
show it to Mr.
absolutely.
Asphalt?
He did, Judge.
Okay. Can you get that from him, please?
Oh, that's right. That's right. I'm sorry. A whole completely new process to me. Yes, correct. It's the, oh, sorry, it just clicked off.
An attorney is definitely needed in this case, or he can hire someone else that we always know have a whole lot of paperwork. You know who it is.
It's a very goofy phone. It is very highly sensitive.
Huh?
I'm not following. This indicates that they've been trying to move you for months. Why haven't you moved?
Because the first time was because I didn't end up finding the paperwork before the 1st of the month. I found out that I have to do it before the 1st of the month.
Okay.
And then there was a whole lot of issues that actually happened between all this. I've been actively looking to get out of there since March. I've been
Okay,
actually
well
trying
then
to
why
get out
can't
of
we
there
do,
since
why
March.
couldn't we resolve this if he's gonna move anyway?
He didn't want to talk to me, Judge.
That was the day that we came.
I'm talking about today.
Oh, sorry, today. Oh, that was because he wanted to drop my lawsuit. He wanted me to drop my
Well,
lawsuit. That's not the case. That's the only part I'm not gonna drop.
No,
When we were in the office, that's what was mentioned.
I said explicitly the opposite, Your Honor, that it was only this case. And
just this case.
I'm moving. There should be no reason why we're here for this, but I still would like to do my trial for the lawsuit, absolutely.
I'm not even, I don't even, I, at this point, I would just adjourn it.
But Your Honor,
He's
I
gotta,
mean,
if he gets an eviction, he can't move.
Exactly, and that's why, I mean, this defendant has been rather friendly, rude to me, and I normally, it doesn't bother me, but
I know.
I'm still willing, we can enter into a conditional dismissal, dismissing this case, giving him until August 4th. My client is okay with it, just as a gesture to move on.
I was gonna say I would have you do a conditional dismissal, but I didn't know if you felt comfortable with it. But if that's what you want to do, that works out, then you don't have to worry about coming back here to get it done. You can move out and the case is over. If you don't move out though, then judgment enters against you in this case immediately. This has nothing to do with the other case that's pending.
I understand
You
that.
recognize that?
Yes, I do, Your Honor.
Okay. And
I'm content with
the
that.
terms will be that he needs to vacate by the 4th, you said?
I believe that's a 10-day. And Judge, let me just ask my client real
No
quick.
problem.
Yeah, that's fine, Judge.
Okay. So the terms will be that he needs to leave by the 4th of,
Yeah, the conditional dismissal will read that he has to turn in keys and vacate the property on or before August 4th, and the case will remain dismissed. If he fails to do either one of those, then we can move to set aside the conditional dismissal without need for further court hearing, a judgment of possession, and a writ could enter at that time.
thank you. And that's
Can
what
it
you want
also-
to, no, we're gonna talk about what I want to talk about right now, not what your aunt told you to talk about.
Nope.
She's not an attorney.
His pro se position is crumbling fast.
Is that what you want to do?
That's not what I was
Is that
actually-
what you want to do?
As long as I am allowed to go through the walkthrough with the landlord. As
You're
long as
always
I can
allowed to
do
go-
that.
You're
I
always allowed
want
to.
that included. I want that included.
You're always allowed to, by law.
I understand that.
By
there's-
law. You
I
have,
want to make sure that that's.
cut me off
noted.
one more time.
Yeah, I
go
also,
ahead and cut me off and talk over me.
I feel a lot of heat coming off that bench.
By law, you have the right and should be present for your walkthrough. You should schedule that. What day do you think you might want to do that?
as long as it's before the 4th. That's
No,
all.
I'm asking you right now because we're gonna put it on the
I
record.
don't know because this is all just starting, so please, Your Honor, give me a second to look at the calendar and I gotta try and work out my work schedule because they keep dragging me in.
So you work every day between now, how are you moving out on the 31st if you have to work?
Because I'll move out on the 31st. I'll carry it on my back if I have to.
Okay, so are you able to do the walkthrough on the 4th?
Yes, yes.
Can we schedule that?
Yes.
Monday, August 4th, does that work?
Yes.
Walkthrough on the
Yes.
fourth. And
Yes,
do you
Your
know
Honor.
what time might work? You work on the fourth?
Anytime during the day is fine.
Anytime after 11.
Let's say 12 o'clock.
That works for
We're
me.
doing a walkthrough at 12 o'clock. Now it's on the record.
I'm sorry.
Now it's on the record. It's a
Yeah,
court
absolutely.
record saying that
Great,
you
great.
are
Thank
going
you.
to do a walkthrough
Thank
on
you.
the fourth at 12 o'clock.
That's all I need.
Okay.
Also, one last thing. August 12th, they have also done another motion to bring me in for eviction. So-
Not on this case, though.
Well, it's.
We're only talking about this case today.
Okay, what's
You
the
can't
August?
you can't confuse me and start talking about another case.
It's for this case. It's for this.
It's not for this case. This is for this case. You
Okay.
have another eviction
Okay.
that's not this case.
I have another eviction.
Yeah, I believe they did a non-payment of rent case, and then they did a termination of tenancy. It's two separate evictions.
He had more going on than I thought.
And by the way, we will be dismissing the non-payment of rent case.
Okay, so now both of them are dismissed, right?
No, well, they're going to dismiss it. They haven't yet. They're gonna move to dismiss the other one.
As long as I move on the 4th, they're both of them are dismissed.
Yeah,
Is
they
that-
just want possession of the property.
Okay, so as long as I move by the 4th, both of those are dismissed.
Yes, for the second
That's all
time.
I need to know. Then yes, I will move. Absolutely. I want to move. I've been trying to move.
Okay, I think that's what I think you all want the same thing.
Yeah. Yeah, absolutely.
Do you want to dismiss your counterclaim?
No.
Okay.
Let's talk about that statement right there. Now, why do you think that attorney asked him so quickly to drop that other case when they decided they were going to drop both of their cases and have those dismissed? Do you think something's legit about the claim that the pro se defendant is making? Put it in the comments.
No, I'm not
Okay.
dismissing the counterclaim.
Okay,
No,
because you
absolutely
believe
not.
that they owe you some money.
Yes, yes,
Okay.
Your Honor.
We'll
So
work
now
through that
I'm
at another
understanding.
time, though. We won't talk about that today.
Understandable.
But
Understandable. Got it.
you're gonna move, this will prevent you from having an eviction on your record, which will allow you to keep your subsidy, okay?
Thank you.
Okay,
Thank you.
do we have conditional dismissal forms over there, Mr. Aston? No? There's some printed over there if you wanna get the paperwork done. You have the right to be represented by an attorney, and we went over this before. You waiving your right to be represented by an attorney? Okay, you also have the right to proceed to trial. You could demand a jury trial or could have demanded a jury trial. You understood that?
Yes.
And you want to waive your right to have a trial in this matter and move forward with the conditional
Yes,
dismissal?
Your Honor.
Is anyone threatening you to do this?
No, Your
Any
Honor.
promises if you waive your rights in this matter?
I'm sorry, say that one
Any
more time.
promises if you waive your rights in this matter?
None.
Okay. Yeah, you gotta understand that partial performance is not gonna satisfy this. So that means you have to move, take all of your stuff, make sure you clean the property, room swept condition, and turn over the keys.
Understood.
And walk through on the 4th at 12.
Yes,
Okay.
understood. Will do.
If you
No.
don't, then they can have judgment enter against you, which will go on your record, and then you won't be able to keep your subsidy. You recognize
Yes.
that?
Understood. I'll just make sure I have everything on video.
Are you okay, sir? What's the matter?
Oh, I'm just thinking, I knew better than what I was doing. I'm sorry, Your Honor. I shouldn't have tried talking over you. I knew better than that. I'm just so burnt out from this. Actually, I don't know why they did.
Judge, never done it. I just check this one and then put down here dismissal, because this is termination, so no money.
You
is
just put
due.
zeros there. Okay, I just put the defendant shall vacate the property no later than August 4th and attend the walkthrough August 4th at noon. I need you both to sign. I checked box number 7, which indicates partial performance will not satisfy this. We've already gone through that. And so you'll just sign that and then we'll be all set.
And LHC will understand this has all been dropped.
It's been
now.
dismissed. We're gonna get you a copy today and you can take it to LAC if necessary.
Thank you.
Mr. Asphalt didn't even draft it. I did.
I just
Yeah.
signed my name to it is all.
Yep, I put exactly what I just said on the record on
I
there.
understand. I understand. I was in the military, just one of those things.
No worries. You should always review what you sign, but I know,
Cheers.
I just want to let you know that I was the one who drafted it.
Thank you.
Okay,
I trust you.
okay. I'm signing and dating it, and I'm going to give you a copy of it right now. Any additional matters for the record?
None, Your Honor.
You're all set. Thank you.
Thank you.
Now, with this case in particular, that shows that going pro se is really not a good thing, especially when you don't know what's going on, because he almost got disbarred. Can he do that? But if he had an attorney, things would have went a lot smoother. He had a lot of paperwork on that desk. It was just too many things, and he got to go to his phone, and then he's halfway arguing with the judge. Even though he apologized, the case was all over the place due to him being inexperienced and not knowing what he was doing. But I hope you enjoyed it anyway. Give it a thumbs up if you like it. I'll see you around on the next video.